Welcome to the ELAI podcast. I'm Anne Lyne, partner at Hay Solicitors and chair of the Employment Law Association of Ireland. Since the announcement of the first wave of COVID-19 containment measures by An Taoiseach Leo Varadkar in Washington on the 12th of March 2020, the way we live and work has changed at an unprecedented pace. The introduction of the emergency measures in the public interest COVID-19 Act 2020 has brought in a new wage subsidy scheme together with a change to the Redundancy Payments Act 1967 in relation to an employee's ability to claim redundancy during layoff. To assist members when navigating these changes and the employment law issues that are arising when working from home, and as we look to emerge from lockdown, ELAI have formulated this Q&A session. I'll be joined by a series of leading employment law experts in the area, including Catherine McVeigh, barrister, Cliona Kimber, senior counsel, and Joanne Redmond, employment counsel with Facebook. I hope you find this podcast informative and that it offers you clear guidance on the legal complexities that are arising at this time. I would like to welcome Catherine McVeigh to our panel. Catherine is a barrister and active committee member of both the Employment Law Association of Ireland and the Employment Bar Association. Catherine is going to give us guidance on layoff, short time, and the tricky issue of contractual requirements and notice. I'll jump right in and firstly ask Catherine, what is layoff?
Thanks, Anna. Thanks so much for having me. So layoff is defined at Section 11, subsection 1 of the Redundancy Payments Act 1967. Layoff is when an employee's employment temporarily ends due to an employer being unable to provide work to that employee. It is more regularly occurring now during COVID-19 as non-essential businesses are being forced to close. If an employee is laid off, employees still remain employees, notwithstanding that they're not doing any work for their employer, or even if they're not getting paid by their employer. The contract of employment is not terminated during a period of layoff, but it is in a state of temporary suspension.
And can you explain how this is different to, for example, short time?
Yeah, so short time is defined in Section 11, subsection 2 of the Redundancy Payments Act, and it is described as a diminution of work. So unlike employees who are laid off and not at work, short time is where an employee remains at work, but their weekly pay or hours are reduced to less than 50% of their normal working hours or pay. There is a mistaken belief that short time has been commenced if there's been any reduction in working hours or pay. But the courts have been clear that there must be less than half of such a reduction. For example, the EAT has found that a reduction of 37.5 hours per fortnight to 24 hours per fortnight, or a reduction to a 3-day week from a 5-day week, did not constitute short time within the meaning of the legislation. This was held in the case of Scally and Helmsworth Limited and Purcell and Ribbage Limited. And the decision of Purcell also highlights that the reduction must be in a particular week in line with the wording of the 1967 Act. The EAT found that a 1 week on, 1 week off work pattern did not constitute short time because it was not a reduction in any given week. This was notwithstanding that the employee was paid monthly, and the consequence of this working pattern was that she was being paid half of her normal wages per month.
Great. So what emergency payments are employees who are laid off or on short time able to avail of?
Yeah, so employees who are laid off can apply for the COVID-19 pandemic unemployment payment. Employees who have voluntarily left their employment are not entitled to this payment. And crucially, this payment is confined to employees who have been laid off without pay. And this exact issue was confirmed in Schmiel and Concast Precast Limited, where the EAT held that it would defy logic if an employee was entitled to both remuneration from an employer while also collecting social welfare. And the EAT found that this would be contrary to the very established principle of double compensation. For employees who are put on a shorter working week during COVID-19, they can apply for the short time work support. And to qualify for this payment, employees must be working no more than 3 days per week, been engaged previously on full-time hours, and must be available for full-time work. It is worth noting that to be eligible for this emergency payment, employees need to be put on a 3-day week or less, which is actually not the definition of short time within the legislation.
Interesting. So when can an employer legally lay off employees or, for example, put the employee on short time?
Yeah, thanks, Anne. So Section 11 of the Redundancy Payments Act provides that an employer can only avail of the statutory layoff for short time if it is reasonable in the circumstances for that employer to believe that the measures will be temporary, and the employer must give notice to that effect to the employee. Now, this belief of an employer that it is temporary has been interpreted quite strictly by the courts, and the reasonable man test will be applied. So in Pasta Fresca Limited in Arson, the Labour Court recently held that an employer may have genuinely believed that a business would recommence trading after that employee was laid off, but an objective outsider would think differently. And similarly, in the case of Hayes and O'Kelly brothers, the EET provided the example of an accountant as an objective outsider. So during the COVID-19 pandemic, employers need to be cognizant of the fact that it is not simply their subjective belief that will convince a court that a layoff or short time is legally justified. Yet the majority of employers might find it quite difficult to anticipate if the measures are indeed temporary due to the unprecedented nature of the pandemic. It is likely that a court may approach such cases post this pandemic with increased sympathy for employers due to the exceptional nature of this pandemic and the uncertainty surrounding the length of time that the pandemic will continue.
And what about if an employee is unavailable for any reason during layoff or short time?
Yeah, that's a really interesting question, Anne. So employees who are not available for work for any reason may actually not be treated as being laid off or put on short time within the meaning of the legislation. So if an employee is unavailable for work due to, for example, having contracted COVID-19 or because they are taking care of a family member who has contracted the virus, this period may not be considered as a period of layoff within the meaning of the legislation. And both of these scenarios were confirmed prior to the pandemic in the cases of Johnson and Knowlesley Caravan Limited and McConville and O'Neill and Brennan Limited. And this may have implications for redundancy payments for employees in the future.
And then for employers, what type of notice must be provided for layoff for a short time?
Yeah, thanks, Anne. So notice is key, and it is the second step in the test for layoff or short time. So firstly, the employer should check whether the contract of employment actually provides for layoff or short time. And even though an employer can seek to imply that there is a statutory right to layoff in short time within the meaning of the legislation, an employer can still argue that there is a breach of contract. And the case of Ferrick and Monaghan Poultry Products confirmed that notice of layoff and short time can be verbal, albeit in Lonergan and Slevin, it was highlighted that written notice is preferable. This is quite distinct from redundancy situations. There's no minimum period of notice required under the legislation for short time or layoff. But it is advisable that employers furnish as much notice as possible to employees and provide reasons why the layoff or short time is required. That is a temporary measure and will be reviewed in a stipulated period of time.
And does an employer have to legally pay employees when they're laid off, or can they lay them off without pay?
Yeah, it's a very interesting question, and there's no right to lay off employees without pay at common law, and this was confirmed by the Circuit Court in Law and Irish Country Meats Limited. In that case, Judge White held that absent a term of the contract to the contrary, an employer's fundamental obligation is to pay the agreed remuneration for the duration that the employee is prepared to work. An employer may be in breach of contract or liable under the Payment of Wages Act 1991. Section 5 of the Payment of Wages Act provides that any deduction in wages is prohibited unless specifically provided for or whether there's an express or implied agreement. This was confirmed by the EAT in McDonagh and Shoreline Taverns Limited. So an express agreement is a written term in the contract of employment, or it can be in a collective agreement. Alternatively, consent from an employee would also amount to an express agreement. And a temporary layoff combined with the COVID-19 emergency payment entitlements may be regarded by an employee as an attractive alternative as opposed to losing their job by reason of redundancy. But difficulties may arise if an employee refuses to be laid off without pay and there's not such a term in the contract. And employers should be vigilant in such situations and seek legal advice where appropriate. Now, if there's no express agreement, and an employer can seek to imply a term of layoff or short time into a contract of employment. The courts have previously held that a customer practice can be an implied term, for example, in that particular workplace or in the industry. However, to satisfy that test, an employer must satisfy the court that the custom is so notorious, well known, and acquiesced that an employee would look upon it as part of the contract. And that test was set out in O'Reilly and Irish Press. Just finally on this point, there's an interesting case from the 1920s called Browning and Crumlin Valley Colliers Limited. And it's regularly relied upon in this jurisdiction. But in that case, Mr. Justice Greer held that the closure of the workplace, which was a mine in that case, was caused by a force of nature, and it was not practicable for the employer to prevent. And in those circumstances, the court allowed the employer to imply a term of layoff without pay into the contract of employment. And although a century has passed in this case, and we may see employers relying on similar arguments in cases post this emergency period, that COVID-19 or an act of God or a force of nature necessitated a term being applied into a contract of employment, allowing employees to be laid off without pay.
What implications does the new Act have on layoff or short time?
So the Emergency Measures in the Public Interest COVID-19 Act 2020 was enacted on the 27th of March, and it is the second emergency act to be introduced during this pandemic. It introduces amendments to the Redundancy Payments Act, which are welcome to employers struggling during this time. The purpose of the amendments were articulated in the digest of the then bill, which asserts that the financial impact of mass redundancies over a short period of time would have a serious impact on the potential for a business to recover. So with that in mind, the new Act inserts a Section 12A into the Redundancy Payments Act, which disapplies Section 12. So in normal circumstances, Section 12 of the Redundancy Payments Act provides that if layoff or short time exceeds 4 weeks or at least 6 weeks within a 13-week period, employees are entitled to write to their employer providing notice of an intention to claim a redundancy payment. But Section 29 in Part 8 of the Emergency Act inserts this Section 12A, and this disapplies that Section 12 of the 1967 Act during this emergency period. The practical effect of this insertion of Section 12A is that employees that are laid off or put in short time during the COVID-19 pandemic are not entitled to claim a redundancy payment from their employer.
And how long is it proposed this amendment to the Redundancy Payments Act will last?
So Section 12A has been deemed to come into operation on the 13th of March, and it will continue for the emergency period. So at the moment, that emergency period is defined in the legislation as expiring on the 31st of May. But this period can be extended by an order of the government. And the Act says that to extend this emergency period, the government must have regard to certain factors. For example, the need to ensure the continued attachment to the labour market for employees who have been laid off or put on short time, the need to protect the employment relationship, and the need to mitigate the increased risk of insolvencies in the event of a substantial number of redundancies over a short period of time, which would result in permanent losses of jobs.
Thank you, Catherine. And finally, can an employer lay off an employee or put an employee on short time indefinitely?
Yeah, thanks, Anne. So employers cannot keep an employee laid off or in short time after the COVID-19 pandemic. And employees may take some comfort in hearing that. But the amendments to the 1967 Act, namely that insertion of the Section 12A, are only in place for this emergency period, whenever that ends. An employee will be entitled to serve a notice on an employer claiming redundancy payment post this emergency period, provided that the necessary requirements for redundancy are met. So in those circumstances, an employer cannot keep an employee laid off or in short time indefinitely.
Great. Thank you, Catherine, for your input. I would like to welcome Cliona Kimber to our podcast. Cliona is a leading senior counsel in Ireland, specialising in employment and equality law, and is the author of several books. She's also chair of the Employment Bar Association. Cliona is going to talk to us about redundancy and the change brought in by the recent legislation, including the wage subsidy scheme. So perhaps if we start with that, Cliona, what is the temporary wage subsidy scheme for employees who are laid off?
Hello, Anne. Thank you very much indeed for inviting me to take part in this podcast of the Employment Law Association of Ireland. I'm delighted to be here. And Anne, you're quite right to start with that temporary wage scheme, because this is one of the main supports that the government has put in place for employees. So this temporary wage scheme was brought in at the end of March, and the purpose of the scheme is to encourage employers to retain links with employees for when business picks up after the crisis. It's a scheme operated by the revenue commissioners. What the scheme does is allows the government to contribute to an eligible employer's wage costs by paying employers a wage subsidy, which is then passed on to the employee on a temporary basis. Revenue will process the supports directly through the employer payroll system. And the subsidy scheme will refund employers up to a maximum of $410 for each qualifying employee. Now, it is different from the social welfare pandemic employment scheme. So for those employers who don't opt into this top-up scheme, the employee can still claim a social welfare COVID-19 payment.
Great, thank you. And for employers, when would they qualify for the temporary wage subsidy scheme?
The employer will qualify for the temporary wage scheme if their business activities are adversely impacted by the COVID-19 pandemic. So the employers retain the staff on the payroll. Some of them may be temporarily working, or some might be on reduced hours. But to qualify, the employer must satisfy 4 main criteria. Firstly, the employer must be experiencing significant negative economic disruption due to COVID-19. Second, they have to be able to demonstrate to the satisfaction of the revenue commissioners a minimum of 25% decline in turnover. The employer has to be unable to pay normal wages and normal outgoings fully. And the employer has to, and this is fairly key, retain the employees on their payroll. Now, there is some flexibility around this, and that the revenue has brought out guidelines. And employers who are interested in this scheme really should be in contact with their tax experts. There is a self-declaration aspect to this. And for those employers for whom the money comes in and the cash flow is somewhat uneven, it's not necessarily a 25% decline in turnover, but it has to be that the employer can show a downturn in business of more or less that extent. But for details, it's your tax expert who will advise. And even if there is a genuine redundancy, as is likely to be the case in many businesses, unfortunately, if the employer is making a decision which employees are to be kept on and which let go, there has to be a fair and objective method of deciding who is to be made redundant. And I should emphasize that it is the role and not the person. So what type of fair and objective method of selection could there be? Many workplaces operate a rule of last in, first out. You might also have perhaps all employees of a specific category. For example, all of the receptionists will go. All of a certain level of seniority would go. all of a particular type of worker would go. But I cannot emphasize enough to employers that this is not simply a decision that Mary is working well, John is not working well, we're going to get rid of John and we'll keep on Mary. It has to be an objective selection process. Otherwise, employers, when this is all over, may have claims for unfair dismissal. Then the next legal obligation of an employer is payment. In addition to the paid notice, employers will also have to pay eligible employees a statutory redundancy lump sum payment. So under law, this is 2 weeks per year of service plus 1 week's normal pay. Then another requirement in order to legally make somebody redundant and avoid claims would be to consider suitable alternative work. An employer might want to consider offering a different type of job if one has become redundant. Again, I might go with the restaurant example. Let's assume that the restaurant is now turning into a takeaway. They don't need the waitresses anymore, but they might have a delivery job. So rather than simply make all of your waitresses redundant, you might say, well, I have a job as a food deliverer, and you offer the waitress that job. Very importantly, employees are not entitled to a redundancy payment if they refuse an offer of suitable alternative employment. So it is worth the employer thinking as to whether there is something else that the employee could do rather than dismissing them by way of redundancy.
So, Cliona, what type of employee is entitled to a redundancy payment?
To be eligible for a redundancy payment, the employee must satisfy a couple of requirements. Well, 4 in fact. First of all, they have to be over 16. Secondly, they have to be in insurable employment under the Social Welfare Acts. Full-time employees under the age of 66 have to be paying a Class A PRSI. They will know themselves from their payslips what they're paying. Slightly different insurability requirements for part-time workers. The most important requirement is that the employee has to have been working for their employer for at least 104 weeks. That's 2 years. Less time, there is no entitlement to redundancy payment. And of course, they have to have been made redundant. And that is a formal notification from the employer that they are being made redundant. So simply shutting the doors and leaving the employee in a state of uncertainty is not the same as being made formally redundant.
And are, for example, part-time workers, fixed-term workers, agency workers, apprentices entitled to redundancy payments?
The first type of people are entitled, that is agency, part-time and fixed-term. They are entitled to a redundancy payment if they meet the usual requirements, that is having been employed for the 2 years, etc. For agency workers, it's the responsibility of the agency to pay the statutory redundancy payment if it pays the workers' wages. Apprentices, on the other hand, aren't entitled to a redundancy payment if they are dismissed just after the ending of the apprenticeship, 1 month after the ending. And that goes really in line with common sense. Most apprentices would imagine that they are employed for the apprenticeship period, but that there's no guarantee after that. But if the apprentice is kept on after the apprenticeship ends for more than a month, then they can have an entitlement to a redundancy payment. But again, they must be between the ages of 16 and 66 and have 2 years continuous service.
So if an employee is made redundant during the COVID-19 emergency period, is that employee entitled to a redundancy payment?
Well, that is a very good question because it is very confusing for employees and presumably for employers as well. So again, I just really have to emphasize that if an employee has been made formally redundant by way of a notice of dismissal by way of redundancy, they are entitled to redundancy payment immediately. Now, if the employer cannot pay or refuses to pay the statutory redundancy lump sum, the employee can apply for direct payment from the social insurance fund. Although, if the employer has money but is simply refusing to pay, the employee may need to have to go to the Workplace Relations Commission to get a formal declaration. But otherwise, the employer and the employee have to fill in various forms. The employer will say that they do not have the money, they cannot pay the redundancy payment, and then there is an application to the Social Insurance Fund for a redundancy payment.
And for employees, how does an employee know they're made redundant? So if, for example, the doors are shut, can the employee take it as a layoff and claim the COVID social welfare payment?
And again, this is really getting into the nitty-gritty of the issues. And Catherine McVeigh earlier will have talked about layoff and the traditional law applicable to layoff. So if the employer just closes down their business and sends everybody home, what is the employee's status? Well, if they're not formally made redundant, in my view, they are likely to be treated in law as being on a temporary layoff. And during layoff, an employee remains an employee, even if they're not being formally paid in the way that they were beforehand. Now, if the employer cannot pay the employee and the employee has lost all their employment, they can apply for the new COVID-19 pandemic unemployment payment through the Department of Social Welfare. The legal status of the employee, if they have simply been sent home without a formal notice of dismissal or by way of redundancy, this means that their contract of employment is simply temporarily suspended. If, when the crisis is over, the employer says, look, I've closed my restaurant or I've closed my business and my coffee shop, I'm not going to reopen, we're now formally closing down. Under law, the employer is required to reactivate the contract in order to dismiss on grounds of redundancy. Now, this means that the employer would have to say, right, I'm now giving you your 2 weeks paid notice, and I'm also then agreeing to give you your statutory redundancy payment if they can pay it. And the employee is then entitled to the full paid notice period or payment in lieu. And that is a normal pay for the redundancy period. And there's a very important point here, is that the employee who has been perhaps on short-time work or no work at all during the COVID-19 pandemic, if the employer then formally makes them redundant, the payment in lieu of notice is based on the hours of work in the contract of employment, not on the short-time hours of work. So if the employee had been on a full-time job and the employer shuts the workplace, and then when the crisis is all over, the employer says, we've lost too much money, I'm formally closing, the employer then has to work out the notice pay and the statutory redundancy lump sum based on the full-time work that that employee did before the pandemic started.
We touched on this with Catherine McVeigh in the context of layoff and short time, but just specifically in dealing with it in this discussion on redundancy, how long can an employee be laid off or kept on short time during the emergency before being made redundant or claiming redundancy?
Yes, and it is worth really being very clear about this, because there is like a before and after the pandemic. The law really looked at this from the status of the employees and trying to avoid any sort of uncertainty, because very many kind of workplaces would have had sporadic or seasonal work. And you'll see the old case law talking about, dockers or some sort of work where people can come and go and be laid on and laid off, or factory work, or if there were strikes or all that sort of stuff. So basically there was a compromise. And before the pandemic, the employer was allowed to lay people off, But after a certain period of time, the employee was entitled to say, look, I've had enough of this uncertainty. I'm now going to elect or claim for redundancy. I'm going to terminate the relationship and go off and look for a new job. I've had enough of this back and forth. And before the pandemic, this could take place after 4 weeks of layoff or short time. Or if you had a sort of a sporadic work pattern, 6 weeks in the last 13 weeks. Now, the new legislation has changed this completely. And as Catherine McVeigh has discussed, the new legislation suspends this. And during this pandemic period, even where there is a lot of uncertainty, as long as the emergency period is there, the employee cannot, if they're laid off or on short time, they cannot say, right, I want my redundancy payment. Now, really importantly, if the employer has sent out a formal notification of redundancy, the employee is entitled to the redundancy payment. So it's only during a period, this uncertainty period where things are closed down, that the legislation suspends the normal rights of the employee to get rid of the uncertainty and say, I want redundancy.
And can an employee take actions against an employer for decisions made during the COVID-19 crisis, for example, a decision to dismiss?
Oh, yes, absolutely. When the dust settles and when this passes, as it will pass, there will be a lot of people who have to look at what happened and look at the situation. So, as I mentioned earlier, you cannot simply use the COVID-19 emergency to weed out people or get rid of people that you don't want. If an employer has made unfair decisions about redundancy, or if they weren't genuine redundancies, then an employee can make a claim under the Unfair Dismissals Act. If an employee has been working for 1 year, they have to have 1 year service, and they believe that a redundancy during COVID-19 was not genuine, or they were unfairly selected for redundancy, they can bring a claim for unfair dismissal. And they can succeed in the full redress for an unfair dismissal. Now, the Unfair Dismissal Act does require substantial grounds to justify a dismissal by way of redundancy. And I think that the COVID-19 pandemic will be a substantial ground. So it's more likely, in my view, that there will be unfair selection for redundancy, where the employer gets rid of people it doesn't like, or gets rid of all the pregnant women, or gets rid of all the older people or the younger people, or something of that nature. And then that brings us into the other pieces of legislation, the Employment Equality Acts, the Maternity Protection Acts. If the employee believes that they have been made redundant for a discriminatory reason, so the employer might say, I'm getting rid of all of the women on maternity leave, or anybody who's pregnant, I'm going to make all of them redundant, or I'm going to get rid of all of the non-nationals, or any of my older employees, the over 50s, I'm going to get rid of all of those, and I'm going to keep on my younger, or I'm going to keep on my men. This could be a discriminatory selection for redundancy and a discriminatory unfair dismissal. And then there will be a possibility for bringing a claim under the Employment Equality Acts. So in summary, Anne, the employer does still have to make proper legal decisions during the COVID-19 period.
And then finally, Cliona, thank you for all of that. Are there any changes in the new Act for jobs that have become genuinely redundant during the emergency period?
I think it's worth going back over that again, just for final clarity. So the new legislation that's come in has made no changes in the law for an employee who is formally notified in writing that they are being made redundant and given their normal notice. That hasn't changed. But where the business has simply shut its doors or sent everybody home, and they're laid off or they're on short time and it's all very uncertain as to what is to happen, That is where the changes have come in. And that stands to reason because the government has put these two schemes in place in order to suspend the situation so that people hopefully will get back to work when this is all over. So the government has, for people who are laid off or on short time, it has suspended the normal rights during a period of uncertainty from their employer to say, I've had enough of this, I want to claim and elect for redundancy. I hope that is sufficiently clear, but people can, of course, get more detailed advice if they have a particular scenario where the situation is not as clear to them as it might be.
Great. And thank you, Cliona, for that whistle-stop tour of redundancy and the wage subsidy scheme during this crisis period.
Thank you very much indeed, Anne. It was a pleasure.
I am joined by our final guest on this podcast, Joanne Redmond, Director and Employment Counsel at Facebook. Joanne is going to share with us her insights on working from home from a multinational perspective, including practical steps for employers when engaging with teams. We will also discuss what the de-escalation phase might look like for the workplace as countries begin to emerge from lockdown. So welcome, Joanne. If you'd like to firstly just tell us a bit about your role with Facebook.
Sure, thanks, Anne, and thanks for having me on the podcast. So I look after the small international employment law team at Facebook, and we cover all of the regions outside the US. So we look after the 10,000 or so employees that we have in the 40 countries that we operate in EMEA, APAC and LATAM. So we're kept busy.
So Joanne, how has COVID-19 changed the concept of working from home, and what implications has this had for employment law?
Yeah, so I think it's safe to say that we are all living in a totally transformed world, not least of all when it comes to the world of work. As a direct result of the current crisis, many companies, including Facebook, have had to explore the reality of remote working from home for the first time and in a situation of some urgency. Some employers, including Facebook, have experience of remote working across many teams, but usually on a more ad hoc basis. And now many, including us, have had to deploy it across almost the entire employee population. So it's been a big shift. So I think we're in a situation where across both the private and public sectors, employers and employees who never envisaged working from home were, over the space of a short 2-week period in March, required to completely re-engineer their work practices to facilitate exclusive working from home. And I think there's no question but that working from home is creating professional and personal challenges for both employers and employees. I think it does seem likely that, to some extent, the genie is out of the bottle and a greater level of working from home is here to stay. I think working from home brings a number of potential employment legal issues into play, which need to be very carefully considered. It also brings a number of practical implications around remotely managing teams, and I know we'll look at that a little later.
And you might tell our listeners, what are some of the main legal issues for employers when considering large numbers or indeed any employees working from home?
Yeah, so I think one of the interesting pieces here is that much of the legal framework we operate in predates much of the technology we use for working from home. So the Organisation of Working Time Act was enacted before Google search engine was invented. The health and safety legislation was put in place before the first iPhone. But while how work is done has changed, the basic obligations of employers towards their employees at work remain largely unchanged, irrespective of whether that work is carried out in an office or a spare bedroom like many of us are in right now, with the addition of screaming kids outside. But turning to the main legal issues at play, I think these largely centre around all things health and safety, both from a physical and indeed mental health point of view, and also from a working time perspective. Other key risk areas include data protection, confidentiality, monitoring of employees, to name a few. I think the key issue is the health and safety piece, and obviously the health and safety of the workforce and of course the wider community must be the key priority during this crisis. If we look at the health and safety legislation, an employer obviously has a duty of care towards their employees. This includes providing and maintaining a safe workplace, preventing any improper conduct or behaviour likely to put the safety or health of their employees at risk, providing training and instruction to employees. Strictly speaking, this means that an employer should carry out a risk assessment of an employee's home office space when they commence working from home. Obviously, this isn't a runner in the current circumstances, and very helpfully, the Health and Safety Authority has issued a really comprehensive new FAQ document guiding employers on how to look after their employees' physical and mental health at home. Employers will be relieved, I'm sure, to hear that their health and safety obligations don't extend to going around physically to all of their employees' houses to inspect their home office. But what might be useful is an ergonomic questionnaire to allow employees to assess the suitability of their home office arrangements. And then employers, if necessary, could take steps to mitigate any risks identified. Employers also have an obligation to ensure employees have appropriate tools to do their work. And in the current scenario, I think that includes both the IT equipment and software, but also the communication protocols to ensure employees are clear as to how work is to be assigned, how technical issues are to be resolved, as well as clear ways to differentiate personal and professional life. And I think this is a really big area for a lot of employees and employers.
And what about then the whole issue of working time and the requirement to comply with the Organisation of Working Time Act?
Absolutely. So, as we know, the Organisation of Working Time Act sets out that employers are obliged to record working time information for each employee on a daily basis. The employer is required to ensure compliance with this, and this includes ensuring that working hours and rest breaks are occurring in line with the legislation, and records of days and hours worked each week are maintained. I mean, in normal circumstances, these obligations are relatively onerous, and the difficulties of recording working hours for remote employees can present an even bigger problem. Many employers may not have an online IT system in place, nor the resources to implement one at this stage, which will capture all the data required. For some employers, a temporary method of achieving this compliance piece via email, for example, may need to be deployed. Some employers of remote workers would have clauses in employees' contracts requiring them to record their hours to assist the employer in complying with their obligations under the working time legislation, and this should help with compliance.
Thanks, Joanne. And just another consideration that you spoke about there, data security and GDPR considerations.
Yes, so I think this is one of the key areas as well, where employers need to ensure that data security is maintained where staff are working from their own homes. Where remote working involves the transmission of confidential information, for example, outside of the workplace, the employer needs to ensure that it has systems and its systems are designed to enable the safe transmission of such data. Having a robust IT system in place with necessary safeguards is obviously important, as to our skills and awareness of the remote worker. So some things that might be helpful are reminders or online trainings that can be utilised to refresh skills in this area.
And then just in terms of some other practical considerations, maybe best practice or tips for our members.
For sure. I think, the legal considerations and the legal risk areas around working from home are obviously really important. I think what's equally important is focusing on employee morale, keeping workplace culture intact, and that really does deserve, equal attention, I think, to the legal risk piece. I think it's clear now that, some people really enjoy working remotely. Others can feel isolated, end up working longer hours. The lines between work and family life, I think, are blurring for many of us. So I think it's important that employees know they have support at all times during kind of working hours. Some of the things that we have focused on in Facebook, I think might sound a bit basic, but I think are really important. So we have a really clear focus on communication. I think now more than ever, employers need to focus on keeping their people connected and informed, setting regular cadence for weekly one-on-one check-ins and team meetings, I think really helps. And if anything, to kind of over-communicate with team members and employees to make them feel supported at this time, with a focus on resilience and setting appropriate boundaries.
And is there any further guidance from the Health and Safety Authority, FAQs, that would be of interest?
There is some helpful guidance in the Health and Safety Authority FAQ. It talks about ensuring contact details for employees are kept up to date and agree a means of contact with employees, because that will obviously vary from person to person, providing employees with emergency contact numbers, making sure work is organised in such a way that employee takes regular breaks and can separate as best they can their work life and their daily life. Also providing employees with regular feedback on their work. Obviously, performance management is difficult at the best of times, but it can be even more difficult when you're doing that remotely. And then also encouraging employees to maintain contact with colleagues. So social Zoom calls are a big feature as well.
Great. And finally, Joanne, as we hope to emerge from lockdown, what might we see in the de-escalation phase for office work?
Yeah, it's a really good question, and I think a lot of companies are now focused on this. All the signals that we see, both in Ireland and other countries, really point to the fact that moving out of lockdown will be on a phased and a staggered approach, and employers will have to work through a laundry list of items, health and safety items in particular, for their workplaces before determining how and when to reopen. So things like how can they ensure safe physical distancing, and what measures can be put in place to protect employee safety, such as staggered start and end times. Some employers I know are looking at splitting teams. So team A on one week, team B on another week, again to ensure safe social distancing. Cleaning regime and temperature checks are also hot on the list.
Very good. Thank you very much, Joanne. That was very informative.
Thank you, Anne.
You have been listening to the ELAI podcast on COVID-19, employment law and the changing way we work. I would like to thank each of our contributing experts for their insights on this topic. The situation is an evolving one, and we hope that you have found this podcast to be informative and insightful. To all our members, take care.